Sara Ackermann. I'm an attorney with Ware in Wausau, Wisconsin, and I focus on employment law for businesses. Restrictive covenants and making sure that they are enforceable. We have in Wisconsin a statute that governs enforceability. It's statute 103.465. And it's very difficult to enforce non-competes. And so if employers want to make sure they have an enforceable document, there are several things to consider in drafting. Well, usually employers will have certain categories of employees they want to restrict from competition. In the health field, for example, physicians usually sign non-compete agreements. In other companies, it's salespeople. And those agreements are usually signed when the employee starts the relationship, and after departure, if they breach the document by working for a competitor, then the question is whether the employer can sue that former employee and whether they can prevail. You need to be very specific. You want a document that is so tailored that the employee knows exactly what he or she can and cannot do. You want to be able to convince the judge that you have a protectable interest in making sure that that employee does not compete. So I always advise my clients to be as specific as possible. One example is that you need to narrowly define what they can and cannot do. We have in Wisconsin something called the janitor rule. And if the agreement prohibits the employee from doing anything for a competitor, even being a janitor, then it's not going to be enforceable. You need to limit it to exactly what they did for you. The judge will always look at how long is the time restriction, whether it's 2 years, 3 years, and where is the employee prohibited from competing from. So is it a nationwide limitation? Is it perhaps a miles radius from a particular location? You need to be as narrow as possible because your job is to convince the judge. We need to restrict for this period of time and for this area. Often I see employers asking for too long of a time limitation. In Wisconsin, it's very difficult to have an agreement enforced if you go beyond 2 years. I often see employers try to overreach in the geography, perhaps asking for a nationwide limitation when the employee only worked in Wisconsin. So those are two very common mistakes. One idea is to make sure that you specifically define what the employee did for you during the course of their employment so that you can restrict them from that activity in the future and being as detailed as possible. And secondly, don't be overreaching when it comes to non-compete agreements. Perhaps if you're only concerned about losing customers, then you can build in a customer non-solicitation provision and not prohibit the employee from working for a competitor. A judge is going to find that more reasonable.